So far we have covered the basic trial process, and we've also talked about fault wrongs, talked about assault, battery, false imprisonment, trespass, defamation, intentional infliction of emotional harm, and we know that there's also negligent infliction of emotional harm, but we've been talking about negligence, and we'll talk about that separately. Anyway, unintentional conduct is negligence, or it's strict liability. Strict liability has nothing to do with fault. So basically, if somebody's being held strictly liable because of a statute usually that says if he engages in this kind of activity or he owns this particular asset, he's liable for any harm that it causes. There's always a connection there in terms of the thing that he owns and it being some way dangerous. And if he's going to own dangerous things, he then has to be aware that he's potentially liable for that. So we talked about all that. And so we talked about the fact that strict liabilities were three types. One is the ultra-hazardous activity. One is also the animals with known dangerous propensities, such as a dog that has attacked human beings. Wolves, wild animals, we'll talk about those. Negligence, we talked about it and we said there's duty, and that's established by custom or statute. Breach of duty, acting or failing to act whenever doing so involves an unreasonable risk of harm to others. Injury, an actual physical harm or financial loss imposed on the victim, and there has to be proximate cause or causation. It's actually two parts to that, but we'll talk about that. So the common law rule in terms of that relates to contributory negligence. So we talked about contributory negligence a little bit. We'll maybe talk a little more about it. And we'll talk about affirmative defenses. Contributory negligence is a affirmative defense. That is, you have to prove it in trial. So you have the burden of proof. If you're going to say that I'm not liable because the other side did something and was at fault for his own injury, if you're going to allege that, you've got to prove that by some evidence. And also assumption of risk, which is a voluntary encounter of a known risk. These two kind of overlaps, the contributory negligence and this assumption of risk. Assumption of risk at common law even covered risk that the person maybe did not involve any sort of fault on his half. That's why they overlap. So the assumption of risk, the risk assumed could be a matter of being negligence towards one's own self. So foolish stunts like trying to walk across the highway on a telephone line would be a very foolish kind of stunt. And if something happened to you, you would probably be deemed to be at your own fault. On the other hand, certain things may be just part of the nature of your business, even, or something that you would normally do. It's no assumption of fault to pursue your work. If you're an electrician, you have to approach a malfunctioning piece of equipment that's throwing off, sparks. Then we're not going to hold that against you. Or we do hold it. We did hold it against you at common law, but I think a lot of states now are moving away from that. So basically, we're going to be talking when we talk about assumption of risk and and negligence, contributory negligence. We're oftentimes talking about something that's dictated by a statute. So negligence is oftentimes by statutes, and if a statute sets out something as negligence, we say, well, that's negligent per se. And the only thing you need to prove in that case is that there was an injury and that the person who, that a person can be held responsible for causing it, that he's the proximate cause of the injury. And we talked about several cases. We talked about Tedlow versus Ellman, where there were two roads, and both of them were kind of dangerous. On the left side, the road was heavily trafficked, and on the right side, the road wasn't as heavily trafficked. But to walk down that road, the pedestrian had to walk, and would be not facing the oncoming traffic, so they would be walking down there, and therefore they might choose or think it's best to walk on the side that's left of the road or right of the road, going down the right side. If they do that, they're going the same way as traffic, and traffic can't see them. And we say that basically that was actually negligence per se, wasn't it? It's negligence per se because they were not supposed to. So some people would say, well, they're absolutely liable then. You know, they're absolutely liable for any harm that happens to them because they had basically it was foreseeable that somebody might hit them from behind. But when you get into the case, it seems terrible because, you know, the driver apparently should have seen them and could have, you know, slowed down and waited for an opportunity to pass them or beeped his horn or something. Instead, he just plowed into them, and that didn't seem to be right. So that was the Tedla case. The breach of duty case that I'm going to talk about. So that was a case that related to duty. Did Tedla have a duty to walk on the left lane where, you know, she would be facing traffic because of the statute, and it was that an absolute duty, and therefore anybody who hit her coming from behind her is going to be held liable? Or should she be able to judge that maybe it's safer for me to actually go on the other side, or I can't make any progress on that other side of the road, it's impossible to pass through there? That's a duty case. Do you have a duty? And a duty, normally you would have a duty if the statute says you have a duty, or if there's a customary procedure about doing certain things. So some things are customary. You put away your tools after working. You know, so that's kind of customary. But also you could have a statute on that too. You know, if you own a pool, it's usually expected you put up a fence or some other barrier so that people will not fall into your pool. If there's a hole in your yard, you do something about it. If there's a hole in your floor, if you have a broken step, you're usually expected to do something about it. This goes up if you were actually a landlord. A landlord would have a heightened duty to take care of the premises that he's in. But any owner of property has a duty to maintain safe premises, and barring that, he should at least put up some warnings or barriers. Barriers are even better, right? So we talked about Martin versus Herzog and the guy in the buggy. And again, you had the situation where he had a light, but he didn't put his light on. But people testified that he should have been seen, he was clearly visible, and that the car that hit him should have been able to see him, and the car that hit him had been going over the line. So the car that hit him was clearly negligent. But you have to remember that under the contributory negligence rule, if you were at all at fault for your, even a tiny bit at fault, 1% at fault, you're going to be barred from recovery. So people would say, well, since there's a statute that says that he's supposed to have a light in his buggy, which he had, but he didn't light it, and it should be lighted, because the statute said it should, he's not able to recover it, although he was on the right side of the road, and the other guy was over the line into the lane, and you know, therefore he's clearly negligent. But under the old rule, contributory negligence, Martin couldn't collect anything, and so that doesn't seem right either, right, to a lot of people. So now we come to the case of Paulsgraf versus Long Island Railroad. I don't remember if I talked about that. In Paulsgraf versus Long Island Railroad, there was a man trying to board a train, and the train was moving at the time, and so a porter and a conductor actually tried to help him board the train, but in the process he dropped a package he was carrying, and unknown to all of them except for maybe the man, the package contained fireworks, and when the fireworks fell below the train, it set off an explosion which caused a vibration on the platform 25 feet away. A lady was waiting to board the train. Mrs. Paulsgraf was waiting to board another train, not this train, but a coming train. She was waiting there, and the weighing scales at the other end of the platform fell over onto her leg and foot, causing injury. And so she sued the railroad because the employees had been negligent in trying to help this person who was clearly not supposed to be boarding at that point. They should, you know, instead of helping him on, they should have told him, no, don't get on, or hold him back or something. And so the railroad seen as being responsible for the injury, and some people said that was wrong, and so actually the majority actually ruled against Mrs. Palsgraf. But some people said it's the case that the dissenting opinion by Judge Andrews was a better opinion. But he had 4 votes, the majority was 5, so that's why Andrews' opinion was not ruling. But other people later said that his opinion made a lot of sense because it talked about her being within the zone of danger, whereas the majority opinion said, well, she was too far away, 25 feet, too far away, not for a vibration, so it's not too far away, right? So that was it. So we're talking about cause here. With the Palsgraf case, it turns on cause. Do you see there's an actual cause? The actual cause is the vibration, which was caused by the explosion, which was caused by the package falling below the platform, which was caused by the man trying to board and being helped by the railroad employees, and therefore the cause is actually traceable to the railroad under that kind of analysis. But that's a but-for example. So actual cause just goes to but-for. What we're really interested in these cases is something called proximate cause. And that's the question, is it foreseeable that somebody will be hurt like this given, the facts? Is it foreseeable that somebody would have this injury? And so we talk about foreseeability. And foreseeable injuries occurred because of those actions. So it is foreseeable that actually, isn't it, that if a railroad employee helps somebody do something that they shouldn't be doing, it might well result in somebody injury somewhere. So, many people say that case was wrongly decided. Anyway, so that's proximate cause, and you need to always establish causation in most torts. You need to show causation where you're trying to collect damages. In defamation, you need to show causation in strict liability for products, and you need to show causation in negligence, certainly. So we usually talk about it when we talk about negligence. So, because it's a big issue in negligence, and negligence is the big tort. That's the one that people are most often sued from. So we've talked about contributory negligence already. So today we're getting into some new material, actually. I mean, we talked pretty much about all of those previous cases. Comparative negligence rule: a plaintiff's damages are reduced by the degree of his own fault. That's the pure comparative negligence. Defendant has to pay to the degree he proximately caused the injury. The majority of states have adopted it. If the state has retained joint and several liability, then the defendant may pay more. And so there was a reaction. I think the insurance people were very upset when states began to adopt comparative negligence. And so there was a lot of resistance from lobbyists from the insurance industry who were concerned that they sold these policies to people based upon their statistical analysis of the losses they were going to have to pay out, how much money they would have to pay out. They said this was going to change the nature of their liability, and they also argued that it's going to require them then to increase their payments in the future. And so there was a lot of resistance from them. And although people thought that the comparative negligence statutes made a lot of sense, that a person should be liable to the extent of his fault, not more, which is what the comparative negligence statute basically provides, requires that you're only going to pay for your degree of fault. Now, the degree of fault is something that the juries determine, and that is largely a very subjective process. But nonetheless, somebody has to do it, and there is maybe no scientific way of laying down the fault on something that happens, because you don't know exactly all what might happen. And if you got two persons who are there, then you have to make some sort of judgment as to how to divide up the liability between them, if you're going to have each of them pay according to their fault. And so, because of that resistance, states that didn't adopt it early on tended to adopt a more modified version of it. And so both Ohio and Indiana both adopted comparative negligence very late, and they adopted the modified comparative negligence. I like to call it compromise, because what it is you're retaining the ideal that where the plaintiff is, say, more than 50% at fault, he can't recover. And of course in Ohio, it's actually, if he's 50% or more at fault, he can't recover. He cannot recover. In Indiana, it's only, the plaintiff has to be more than 50% at fault. So some people call it the 51% rule. Okay, and the Ohio rule is maybe the 50% rule. I usually call it the Ohio rule and the Indiana rule because I'm teaching here. And I think it's important for you to know that there is two different rules. If you have an accident down along the border between Ohio and Kentucky, you might ask yourself, now which side do I want this case to be litigated on? You know, and if you can convince the policeman to put the case in the state that you would prefer, well, you might be tempted to do that, right? Or would you just do it according to what you honestly think this is the place? And do you know where the line is anyway? That's another question, right? So, and why should it make that much difference that you're completely barred from any recovery? If you're, you know, if you're 50% at fault, you're completely barred in any recovery on either side. In Ohio, if you happen to be only 49% at fault, you can still be getting recovery because it's a 51% rule. So why should that slight difference really make that much of a difference? Does that make sense to you? Doesn't that make sense to me? Anyway, so Ohio has the 50% rule, comparative negligence. In 1980, Ohio became the 35th state. You see, there's 35 states that adopted it. 34 states adopted it before Ohio. And that was in 1980, they became the 35th state to enact a comparative negligence law. In Ohio, if a party is more than 50% at fault, recovery is not allowed. In Ohio, if he's 50% or more at fault, recovery is not allowed. Okay. In Indiana, you have the 51% rule. In an action based on fault, any contributory fault chargeable to the defendant, it diminishes proportionally the amount awarded. So this is true in Ohio too, basically. Above the line, you know, where you know, as long as the plaintiff is not 50% at fault, above the line, so 50% or less at fault, he would be able to make a recovery, and therefore the defendant was going to have to pay for maybe a 50% case. You know, so you know, if he's 49% at fault, that's, you know, any contributory negligence to the, you know, the defendant is going to have to pay 51%. So chargeable to the claimant. So the below, you know, when he's less than 50%, he actually can get a recovery according to, it's only reduced by his fault. And so you just have the common law rule kicking in above, where it's above 50% in Indiana. Okay. In an action based on fault that is brought against one defendant or two or more defendants who may be treated as a single party, the claimant is barred from recovery if the claimant's contributory fault is greater than the fault of all persons whose fault approximately contributed to the plaintiff's damages, which is interesting. You can have a case where somebody, two people are like 25% at fault, and in Indiana you have a plaintiff who's 50% at fault. He can recover if he's 51% of, you know, if he's 51% at fault, he cannot recover. Why are these 25%ers having to pay when no, in another case where you only have one defendant and he's actually, you know, 49% at fault, you know, or 51% at fault, he's going to have to pay the full 51%. So why is that? So in one case, a party who's clearly should be paying because it's 51% of fault maybe from in Indiana, under Indiana's rules. Surely you should pay. But in other cases where you have people who are less at fault, they're winding up paying. And so that's somewhat odd. Anyway, and so I'm going to look now at another case, Hoffman versus Jones in Florida. So Florida adopted, as did most states. I've got a list of states here that are still on contributory negligence, still using contributory negligence, haven't moved to that. The terms contributory negligence and comparative negligence is slightly confusing. The two theories now commonly known by these terms both recognize that negligence of a plaintiff may play a part in causing his injuries and that the damages he is allowed to recover should therefore be diminished to some extent. The contributory negligence theory, of course, completely bars recovery, while the comparative negligence theory is that the plaintiff is prevented from recovering only that proportion of his damages. That is, when it's pure comparative negligence in a state that has adopted the pure version of it, he's only going to have his recovery reduced by his degree of fault. If he's 5% fault, it'll be reduced by 5%. If he's 95% fault, it'll be reduced by 95%. The plaintiff's, the defendant's still going to have to pay 5%. It's a small amount in most cases, but some cases, I suppose. Well, let's say that what we're talking about is professional negligence with an accounting firm, and so the accounting firm is doing an audit, and they, for some reason, neglect their duties while doing their audit. That is, they just don't look into certain papers that they should. They don't ask some of the questions that they should, and the jury determines that this was negligence on their part, and they should have seen that this was going to cause the company to fail, and that people who invested in the company would have lost their money, and now there's a lot of money being lost. And the people who could be at fault might actually be, primarily at fault might actually be the firm's accountants and the firm itself. So the firm has its own accountants to prepare the books, and if they are negligent, or maybe they're not just merely negligent, maybe they are actively cooking the books, right? And so if the accounting firm that does the audit doesn't catch it, and it turns out that it didn't catch it because it neglected to do something that it should have done something, so it was negligent, in that case, the accounting firm may wind up paying the entire amount because the firm can't pay because it's actually broke, right? And the agents may also, they lost their job, they can't pay, or you can't trace, you can't show that they have any money, and so you can't collect from them for some reason. And so the accounting firm, although it's only 5% at fault, might have to wind up paying for it when most of the fault lay with the actual firm that had cooked the books, or its accountants had cooked the books. And so that could be a lot of money. And so that's what we would talk about, joint and several liability. Joint and several liability, if one party cannot pay, one defendant cannot pay, then his liability gets shifted over to other defendants, and they are made to pay his share. And they then acquire the right to go after that party who didn't pay to try to collect what they paid. Good luck, right? You couldn't get any money from him because nobody knows that he's got any money, or you can't trace it if he has it, or he doesn't really have any money anyway. So all you can do is send him to jail, maybe, if he didn't escape. Maybe he hopped on a plane and went to Switzerland or something, I don't know. In terms of contributory negligence, comparative negligence is slightly confusing. The two theories now commonly known by these terms both recognize that negligence of a plaintiff may play a part in causing his injuries, and that the damages he is allowed to recover should therefore be diminished to some extent. The contributory negligence theory, of course, completely bars the recovery under the old common law rule. So if I give you a problem on this, I'll tell you to apply the common law rule. I said, well, it's a common law jurisdiction, that means you apply common law. Or I say it happened in Ohio. Or I say it happens in Indiana. So you have to apply the modified negligence rules of those states, which are slightly different. So you need to know what the rule is, and you need to be able to figure out what are you going to do with that. And I'll usually ask you how much money can they collect. In some cases, in Indiana, they may not be able to collect. In Ohio, they may not be able to collect. But in a lot of cases, they might be able to collect if the amount of damages, if their fault is, if the plaintiff's fault, isn't that great, they might be able to collect something. And so you have to figure out how much it is. That's the way I'm usually asked these questions. So. Contributory negligence theory, of course, completely bars recovery, and so the plaintiff is prevented both from recovering only that portion of the damages for which he is responsible. And the interesting thing is, under the old common law rule, if we talked about contributory negligence, it was like absolute liability for the plaintiff because of the old rule about contributory negligence completely barring you from any sort of financial benefit in a case. Okay, contemporary conditions must be met with contemporary standards. So one judge in dissent argued that contemporary conditions must be met with contemporary standards, which are realistic and better calculated to obtain justice among all of the parties involved, based upon the circumstances applying between them at the time of the question. So, the rule of contributory negligence as a complete bar to recovery was imported into the law by judges, he points out, and that whatever may have been the historical justification for it, today it is almost universally regarded as unjust and inequitable. So I think most citizens, even in states like Indiana, are not really approving the law that they have in terms of contributory negligence. Yeah, they have comparative negligence, but there's still this bar to recovery. And so it doesn't seem to make sense to a lot of people that one party would simply be able to walk away and not pay anything, even though he was to some degree at fault. And maybe, actually, I think, let's say you're 45% at fault. That's a large amount of fault. So why shouldn't the other person be able to collect 45% from you to defray his damages, so to speak, because you partially caused those. And of course, it is a judgment. Like I said, it's a subjective judgment made by the juries. Okay, so unjust and inequitable to vest the entire accidental loss on one of two responsible parties. In an effort to ameliorate the harshness of contributory negligence, other doctrines have evolved in tort law. Before they came to comparative negligence, there were other doctrines that came in, such as gross, willful, and wanton negligence. In some states, if you were a party who was grossly, willfully negligent, the jury might wind up giving you a very low amount of the damages, and so the judge might be justified in deciding that you were actually, you had committed big negligence, gross negligence, okay? And so if you committed gross negligence, he might say, well, we're not going to make that other party, we're not going to reduce his recovery by that 5% because you were so much more at fault than he was, and we don't think it really should be held against him that way. And so judges will instruct the jury if the jury is to apply this law. And can jurors be expected to honor such an instruction from the judge? I think they can. How about where the judge instructs the jury that they should apply the contributory negligence law to deny a plaintiff, like in the Tedlock case, deny that plaintiff any recovery? Can you expect them to actually follow through on that? And that's a good question, I think. Disrespect for the law engendered by you putting out our citizens in a position in which they feel it is necessary to deliberately violate the law. So jurors can actually do that. They can decide they're not going to enforce the rule. They can be instructed by the judge to do something, and they can completely ignore it. And something, it shouldn't be lightly brushed aside. And so basically what this judge is saying, that it happens all the time. Jurors will not cooperate with these instructions if you tell them to do these things. and it comes it comes from the mouths of lawyers. And even if it comes from the mouth of lawyers who, as officers of the courts, have sworn to uphold the law, to defend the present system by arguing that it works because jurors can be trusted, is to disregard that very law. Okay. We feel the time has come for this court to join what seems to be the trend towards almost universal adoption of comparative negligence, and he's advocating actually pure comparative negligence. A primary function of the court is to see that legal conflicts are equitably resolved. In tort law, the most equitable equitable result can be reached by a court is the equation of liability without fault. You know, comparative negligence does this better than contributory negligence. We would be shirking our duty if we did not adopt that doctrine. Therefore, we now hold that a plaintiff in an action based on negligence will no longer be denied any recovery because of his contributory negligence. So, on reversing this decision of the lower court, the court is now basically adopting comparative negligence. Should a court be changing the law? This law was created by a court, a judge, originally at common law. It was a common law rule in the history of the common law throughout the 19th century and the early 20th century, and most of the 20th century actually. Common law judges would change common law rules, and you know, judges saw themselves as having that power to do it, even though there were legislatures. But there had been criticism starting in the late 19th century about judges, you know, writing laws and passing legislation, and therefore the whole thing kind of comes into that. Now, if you believe in original intent, you have to kind of think, well, didn't the founding fathers at the time of the Constitution know that they were setting up a judicial system and that there would be judges, and that those judges were going to continue to do this thing that they did? And even if they didn't realize it at the time, why didn't they do something afterwards when they realized that the judges were doing that? They didn't. So we had a whole century where judges didn't do it. More than a century, actually, more like a century and maybe 2/3 of a century, or or maybe more than that. So anyway, in tort law, the most, you know, I said it, okay. We now hold that in an action based on negligence, no longer a party no longer be denied any recovery because of his contributory negligence. So that was the case of Hoffman versus Jones in Florida in 1973. So, you know, even as late as that. So, you know, so there's that was before Ohio, right? By the way, the Indiana statute on comparative fault statute, it's called, was passed in 1984. I know that because I was teaching here at the time. So it went into law, and so I told my students, well, now we have this comparative negligence. Or really, do we have comparative negligence? Not really. We have a modified comparative negligence. Now, what is that? And you know, I'm telling you, it's called in the book modified, but I call it compromise, because you actually have the old rule, the old common law rule, being imposed at a certain extent, to a certain extent, when the party's there. So let's look at a California case in 1975. California had already adopted, the rule. The court, sitting without a jury, found as facts that defendant Phillips was traveling at approximately 30 miles per hour when he entered the intersection, that such speed was unsafe at that time and place, and that the traffic light controlling southbound traffic at the intersection was yellow when defendant Phillips drove into the intersection. So, you know, he's taking a chance, isn't he? It also found, however, that the plaintiff, you're supposed to stop on a yellow light, okay? It also found, however, that the plaintiff actually was shown to have been speeding through the intersection. It also found, however, he sped up when he saw the light changing. You know, he sped up. People will do that. And you kind of wonder, well, don't they care about their life? Anyway, it also found, however, that the plaintiff's left turn across the southbound lanes of Alvarado was made at a time when a vehicle was approaching from the opposite direction, so close as to constitute an immediate hazard. So basically, both sides were at fault, right? The plaintiff seen the defendant, the plaintiff saw the defendant coming, and he maybe should have done that. So, the question here is a less clear chance. Of these two parties, which one of them had the less clear chance of avoiding the accident? Was it the party who saw his party coming? And so I'm inclined to say it was the party who was a little further off had a less clear chance of the chance. So now, if you're going to enforce the, as some courts have done, if you're going to enforce the negligence per se and contributory negligence in the absolute way that it was done under the common law, then it's very important that the plaintiff have the less clear chance. The contributory negligence bars recovery against a defendant whose negligent conduct would otherwise make him liable to the plaintiff for the harm sustained by him. So I mean, basically, the plaintiff here, entering into the intersection, seeing the other car coming, you could say that the other car coming had a less clear chance because he could get in there. Also, he's coming, and he's going actually a little further around the plaintiff to get to that spot, but the other car is not that far away. Anyway, and so that's what I wanted to talk about tonight. Okay, next time when we meet, we will be talking about joint and several liability a little bit more in depth, and we will also move into starting to talk about strict liability, which of course is liability without fault, and we get into some interesting kind of cases there where ultra-hazardous activities, things like, is your company producing things that are highly toxic or highly radioactive? Well, any radioactivity would be bad, right? So that would be an ultra-hazardous activity. Or are you operating a gas station? Gasoline is an ultra-hazardous substance. It can explode, catch fire easily. The vapors can catch fire. We've seen that before. And when we talk about contracts in certain cases, I remember talking about that. And so that would be something that we would need to talk about. And then also we'll talk about animals, and you can be liable for your animals that you keep. Some farmers have animals, and if you're a farmer and your cow escapes from your fence, gets through your fence, let's say that the wind blows down your fence, now you might say, well, it's no fault of mine that the wind blew down my fence and my cow got out on the road and was blocking traffic and got hit by a car and the car was damaged, and he now is trying to sue me for my car being on my cow being on the road. Well, people have been held liable for that. The farmer has a duty to go out and collect those cows. Well, he probably should try to get them into the barn before the storm comes. And of course, that's maybe not always possible. But also, a lot of people become aware of it in terms of the pets that they keep. So if you have a dog, you know that if your dog attacks somebody, you can well be held liable. Nowadays, we've moved way beyond, I think, the old common law rules in this regard, and we now are generally talking about statutes. So I'm going to go over the statutes that we have in Indiana, and not only can you be liable if your dog bites it, you can also be held criminally liable. You can also not only have to pay money in a civil suit, but you might also wind up in a criminal suit. Might be only a misdemeanor case, but it could actually be a major case, a felony case. And in Michigan, there was a case which we're going to go over, talking about an individual or two individuals who owned some dogs, and they were criminally prosecuted. Now, what circumstances caused them to be criminally prosecuted for murder? And they wound up with, I think, a 15-year sentence. That was after a plea bargain. So we'll talk about that case next time.